The process of adoptions is probably one of both the easiest and the hardest areas of law that we do. It's the easiest because there are statutes that guide us how to do an adoption. It's the hardest because those statutes have to absolutely be followed to the letter. And so it makes it extremely hard, if not impossible, for just a regular person a lay person to go in and look at these statutes and say, well, here's what I need for my documents. So at the beginning of an adoption, you of course have a petition, and you have a different set of petitions depending on what the situation is. So if you have a step parent who is adopting a child, or if you have an immediate family member such as aunts, uncles, grandparents adopting a child, that would be a different one. Or if you have no family relationship whatsoever, it's a third-party adoption where there's no relationship or no immediate relationship. That's a different set of adoptions. If you're going through the process through DFACS or some other sort of state placement agency, that's another set. And so as an attorney, the first thing we have to do is decide where do we fit within the adoption process as to what type of petition we have to prepare. And then of course, then you start gathering all the different types of documents that you have to have for an adoption. You have to have birth certificates, marriage certificates. You have to have a background information form that lists out what happens as far as the medical history of the child going through grandparents, aunts and uncles, and those sorts of things. You also have to do, depending on if it's a situation where the father is not the legitimate father, meaning they haven't gone through the legal process to be declared legal father in a case where the child is unmarried, where the child is a child of an unmarried couple, then you have to do what's called a search through the putative biological father registry, and which is a state agency where we send a form to, and they send us back whether or not the putative biological father is registered. And that registration can be done for that either through a form submitted to the agency itself, or if the father happens to be on the birth certificate, they're automatically entered on there. So those sorts of things we have to do at the front end and basically gather a ton of documents just to even attach to the petition. Once you've gathered all those documents, you would then file everything with the court. Once everything's filed with the court, you then have to go through a background check, which most courts require for every set of prospective petitioners who are adopting a child. And then you will have a termination of parental rights if needed. If you don't need a termination of parental rights because you have a set of surrenders for the parents, you would have those filed with the court, and then you would go to the hearing after that. But gathering all of those documents, preparing them, particular surrenders and things like that can be quite difficult. Just on the surrenders alone, there's a surrender, an acknowledgement of surrender, and then an affidavit from the petitioner's representative saying, I've explained the surrenders to them. So you've got, just for one parent, you've got a set of 3 documents just governing the surrender of parental rights, which can be difficult to navigate. You've also got an affidavit from the biological mother, which is basically an affidavit telling the court who the father is, whether the father is a member of a Native American tribe or an Alaskan Native, whether the father is a member of the armed services, because those things are important to determine. And you add that in on top of that to the other documents that have already been prepared. It's quite complex. And so an attorney navigating this paperwork is why adoptions are so difficult to do if you try to do them without an attorney, because the process can be quite daunting if you try and look at these things from the statutes, because you're being referred to 3 different statutes to actually just attach things to your petition in the first place. And so we would gather all that stuff together, file it with the court, get file stamp copies back. The court would set a hearing, you do the background checks, and then 4 to 6 months later, depending on how the courts are going these days, you would have your hearing in front of the judge, which those are sealed hearings, but they're usually nice family affairs that the judges really enjoy, take photographs and things like that. So it's a good place to get to at the end of it, but getting there is a little difficult.